Hi, Matt O'Connor from the O'Connor Law Firm here to explain from start to finish the process of a criminal trial. The first thing that happens is your first appearance. At that appearance, you can expect that the judge will offer to read you the charge, find out if you have an attorney. If you have hired an attorney, your attorney will be there with you most likely. If you can't afford an attorney, then a public defender application will be given to you and you'll fill that out, and before your next court appearance you'll know whether you've been appointed a public defender or not. All that happens as the first appearance is you appear, you find out what the charge is, you're given a new date. At the second appearance, what generally happens, on a felony at least, is that the court will ask whether there's going to be a preliminary hearing or not. And you and your attorney should have met at that point and determined whether or not having a preliminary hearing is in your best interest or not. Now, what's a preliminary hearing? A preliminary hearing is not a trial. And in fact, probable cause, it's the lowest standard we have in the law. It's reasonable doubt is here. Probable cause is like here. Is it possible a crime was committed? Is it possible that you committed it? But what you can get from a preliminary hearing is a good look at what the evidence is going to be, at least a part of it. Now, the state doesn't have to put on all their evidence because their burden is not that high. But you get a sample, maybe a couple officers' testimony, a key witness, and you can bring a court reporter, which means you get one more statement under oath. So when you go to trial, you've got their police reports, you've got the preliminary hearing transcript, and then later you can take depositions, which I'll explain in a moment. So if the court determines that there's probable cause to bind the case over, you'll go from associate circuit court up to circuit court. And that's where the case can be disposed of at a felony level. And again, you're going to be arraigned. Sounds terrible. Arraignment. No. It's where you walk up there, parties announce their presence. I say I'm Matthew J. O'Connor on behalf of John Doe, enter a plea of not guilty, and waive formal reading of the information. All that means is that you're waiving the judge reading it to you line by line. The only other way to get to circuit court without a preliminary hearing is one of these weird proceedings that we still have in our country called the grand jury proceeding. If there's a grand jury proceeding, your lawyer doesn't get to be present. You may be called, you may not even know about it, and you can be indicted and skip that whole associate circuit court proceeding. So, back at circuit court, you've been arraigned. The court will most likely set it on a docket call. And a docket call is just like it sounds, because there's things that need to be done, or work that needs to be done on your case while the case is still pending. For example, discovery. What is discovery? Discovery are all the reports, whether police reports, lab reports, pictures, videos, all those things, according to Rule 25.03, that the state has to turn over to your attorney or you within 10 days of arraignment in circuit court, okay? Now that's the most important part. Now their duty is ongoing. Is the discovery the be-all, end-all of the case? No. That's really when the case starts. That's just the allegation. That's one side of the coin. There's a lot more to do. So once you get the discovery, determine what the witnesses are, what I usually do is go through and go good fact, bad fact, or neutral. If it's a bad fact, you want to do what with it? Neutralize it. How do you do that? A motion to suppress. What's a motion to suppress? Well, people used to call this like a technicality. And you know what? The Constitution's not a technicality. You have a right to be free from unreasonable search and seizure. That is, the government can't kick in your door and cavity search in the middle of the night just because they feel like it. They can't pull people over just on anonymous tips. You know why? Because if you didn't like somebody, you could call up and go, so-and-so has a whole, you-know-what of heroin up his you-know-what, and he's driving down the highway in a blue Ford. They have to have some sort of corroborating information. So for a valid search, for example, a search warrant, they have to get a magistrate or judge to sign off on it and find that there's probable cause and that there's corroborating information to justify the search. If it's a car stop, there's got to be a chain that goes from start to finish, that there's reasonable suspicion that criminal activity is afoot. For example, the officer pulls you over for speeding and he notices a pot pipe in the back seat, that gives him reason. That's the chain that goes in there. So a motion to suppress, there's a hearing on that, and that's to determine whether or not the government has violated your constitutional rights. The burden is on them. The burden is always on them. You know why? Because if they want to put you in prison, they got to prove it. Okay? So motion to suppress, another good opportunity to see, look at all of the evidence that's going to be at trial and another transcript potentially. So now you got the police reports, preliminary hearing transcript, the transcript from the motion to suppress, and the depositions. Now, what are depositions? Depositions don't take place in court. You file a notice. Let's say you want to depose the state's main witness or all of them. In my case, I always depose everybody. I want to know what they're going to say, how they're going to say it, why they're going to say it. Because what's written down in the reports ain't all the story. So at a deposition, it's usually either at the prosecutor's office or at a neutral location or perhaps the defense attorney's office. A court reporter comes in, takes down everything that's said. The person's under oath. They get a chance to sign it, read it before it's used in court. The reason that's important is if the witness says that I was wearing a orange shirt on the police report, in a trial, he says I'm wearing a blue shirt, I can seek to introduce that deposition as what's called a prior inconsistent statement. It can be very useful to show that the person is changing their testimony. All right, so day of trial. Your lawyer has done their investigation, turned in your evidence list, because just like the state has to give their list of witnesses, the defense has to, after a certain period of time. You can add witnesses later as they come up, but you have to have court permission. It's called a motion to list additional evidence and list additional witnesses. Let's say you've got an alibi witness. I wasn't there. Or let's say you've got an expert that you want to call on forensics, whether it's blood splatter or computer technology or protocols and procedures for personnel at a nightclub. This was reasonable conduct under the circumstances, things of that nature. An expert, someone qualified to testify. But keep in mind, throughout this whole proceeding, to be successful, it's not just that there's reasonable doubt, because let's face it, people these days, they want to do the right thing, and that's a good thing. And I don't think it's safe to place your freedom on the line while just saying, well, they can't prove the case. You have to have a cogent, consistent theory of the case, or better yet, the truth, from start to finish. And you have to remember something. People's attention spans are very short. I doubt that a lot of people are still paying attention to this, because we're running 7 minutes of me talking now. That's a long time in today's society. So it's like Yogi Berra said, you got to tell them what you're going to tell them, you got to tell them, and you got to tell them what you told them. And that is in jury selection, opening statement, direct and cross-examination of the witnesses. Now, the key part of a trial, in my opinion, is jury selection. And that's where you need to do your research, not only the local people and what you're given by the court. You really can't do much outside research about the jurors. There is some limitation on whether you can look at their Facebook pages, social media, things like that. Great scene in the movie The Judge, one of my favorites. We used to use this a lot. What bumper stickers do you have? You can tell a lot about people. My goal in jury selection is to get people talking, whether it's about germane issues or not. Because people who don't talk, there's usually a panel of, we call a veneer, of 46 people. And of those 46, 12 are selected. Sometimes you have an alternate, maybe 2. So there's 12 people and 2 alternates. And by the way, nobody knows who the alternate is. That way they pay attention just like they should, because they're thinking, well, if I'm the alternate, I don't have to pay attention. That could be a bad thing. All right, so what are you looking for in a particular case? It varies with every case. The details of the case, you have to know the details of the case. You have to know the details of the particular county or jurisdiction you're in, and understand sort of what the people are thinking in that area. If there's been a rash of these type of crimes, and back at arraignment, if it's a case where the county's under a certain population, do you want to take it out of the county, do a change of venue? I particularly like to do that because, well, I don't like playing on somebody else's home turf. You know, if the Chiefs are going to play at Arrowhead, I like that. If they're going to play in Los Angeles, not my favorite. So if we're going to both play on neutral ground, that's a better deal. All right, so jury selection. You ask questions like, Anybody related to law enforcement? It's not always a bad thing. Is anybody had a bad experience with crime? That is, victim of crime. Those are standard questions. Does anybody have any strong opinions? Let's say this case is about illegal transportation of poultry. Does anybody have any strong opinions about that? And how you get rid of jurors that you don't like is very simple. You ask them questions that the belief that they have is strongly held, and that despite their best intentions and wanting to be a good juror, that they won't be able to just change their opinions based on the judge telling them to follow the law irrespective of their long-held opinions. For example, sometimes it comes up, you get someone who it's their moral or religious belief that they're not supposed to sit in judgment of other human beings. And that's someone who's not qualified to be a juror. And how are you going to change that? You can't make him. First Amendment protects them. So again, back to jury selection, my goal is to connect with the jurors, talk to them, and find out where they're coming from. The people, a lot of criminal defense attorneys end up letting jurors on who don't talk. And if I don't know anything about these people, if I do an average job in jury selection, I got a pretty good feel for everybody. The ones who are quiet are the ones I'm most likely to strike. See, after you get your challenges for cause, those are the ones I was talking about. You know, you have these deeply held opinions. If they say that they couldn't change that, even if the judge gave an instruction that would keep them from being a fair and reasonable juror, then they can be stricken. So that's without your preemptory strikes. Then you get 6 just because. You can pick 6 people off of there you just don't like. And there may be people who didn't talk. That's something to be well aware of. Okay, so you've got your jury impaneled. And by the way, the prosecutor gets to make those same 6 strikes, and they get to make challenges for cause. And at every step of the proceeding, the prosecutor has to go first. Why is that? They have the burden of proof. So, their first witness, they're sworn in. Direct examination is, what happened. It always reminds me of that movie, Dude, Where's My Car? Seems like a lot of prosecutors do direct examination. Well, what happened? And then. So, cross-examination is the key. And again, keeping a cogent theory of the case, the truth, you do cross-examination by telling your story. For example, if I was cross-examining me right now about what I'm wearing, I would say, black jacket, yes. Black tie, yes. Blue shirt, yes. Glasses, yes. You get them in a rhythm, and you tell your story, and then you loop it back, so you're doing that 3 times. Tell them what you told them, tell them what you're going to tell them, all that. And it has to be, again, consistent with your theory of the case. Now, when the state rests, that is, they've called all their witnesses, you file what's called a motion for judgment of acquittal at the close of the state's evidence. And there are some cases, very rarely, that you can win at that, where they haven't proved the elements, because they've got to prove all the elements. If it's receiving stolen property, for example, you've got to have the value. If it's over $750, if that's what the statute says, you've got to have possession. This person was aware and possessed this particular property, and most importantly, that they knew or had reasonable likelihood that they did know it was stolen. Like if you bought a new Mercedes for $5, chances are that might be hot. But if you didn't know it was stolen, and they haven't proven that, or if it didn't happen in the jurisdiction where it's alleged, let's say you've got a crime that happened in Platte County, and they're trying the case in Clay County, jurisdiction, it's gone. So if the judge believes they haven't proven their case, he or she can dismiss the case at that point. Then the question becomes, what evidence do you put on? And a very wise lawyer, Tom was his name, once said, don't create evidence. Sometimes by taking 1 step forward, you might take 2 steps back. You have to be very careful. If it's a case where the state's investigation was shoddy and there's a lot of questions, don't answer them by putting on evidence. And then it becomes, well, do you have an expert? Do you have other people who are favorable? You might have somebody that the state didn't call who ends up being a good witness for you. I've had that happen where maybe there's an officer who observes something that's favorable to my client. I'm going to call him in my case. Then I do direct, where I get to go, all right, officer, how long have you been a police officer? Da, 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 da. and on such and such night, where were you and why, and then they tell what happened. So then the last real big decision, this decision really should be made well in advance of trial, is whether your client's going to testify or not. And if the decision to testify is not the lawyers, not the judges, it is that person's right. Under the Sixth and Fifth Amendment, it is only your right to waive your right to testify or choose not to, and they can't make you. Now, if you're on trial for robbery and you've got 6 robberies, my advice to you would be do not testify, because you know what, they're probably going to take that into consideration even though they're not supposed to. Now, if you're on trial for murder and you've got 5 speeding tickets, no big deal. But the question is, what do you gain by testifying? And if I've done my job in jury selection, I explain to the jurors, hey, John Doe has already said he's not guilty. He stood before this judge and said he was not guilty. That's why we're having a trial. And really, if John Doe got up here and told you right now he's not guilty, you all go, okay then, boom, walk him out the door? No. There's a lot to lose. People get nervous when they testify. They can flub up. It's a risky procedure, and it depends on how they present. Sometimes it's necessary, but again, that's a decision that the client only makes with consent, well, not consent, with advice from their lawyer. So, after all the evidence is in, the jury instructions are most important. The jury instructions are then read to the jury, and they're supposed to follow these. It talks about the presumption of innocence. It talks about beyond a reasonable doubt. And it talks about the elements that the state has to prove. And if they don't prove one of them, I always say that it's like baking a cake. If you don't have flour, or you don't have sugar, or if you're making a chocolate cake, you don't have chocolate, you don't have a chocolate cake. They got to have all of them, each and every element, beyond a reasonable doubt. And I hammer into people because it's true. What's the most important thing in our society that Americans are most protective of? What is it? Freedom. And that's the reason we have the highest burden of proof. Proof beyond a reasonable doubt takes someone's freedom. In a civil case, it's preponderance of the evidence. It's like 51-49. Beyond a reasonable doubt leaves you firmly convinced this person's guilt, that they committed each and every act alleged in the charging information. If they did not, then the law, justice, requires that the person is found not guilty. So the prosecutor gets to argue first, and then the defense, I get to get up, give one argument. This is the part I don't like. They get to give what's called sur rebuttal. And that's where you got to make sure that you're playing chess well, because you don't want to leave your king in a position where the prosecutor comes up there and just goes whack. You don't want to leave an argument hanging. You want to make sure that you've given every argument. Really, the key in closing argument is not to hear yourself talk. It's to give the jurors things to argue that are with you when they go back into deliberation. The facts, the conclusions you can draw from the facts that indicate that you are on the good side, that this is the truth, that innocence is at stake here. After the after closing argument, the jury deliberates. That can go on as long as the judge allows it. So let's say they get stuck. They're like, 10-2 or something. There's this thing called a hammer instruction that the judge can and usually does give, which basically says the trial takes a long time, there's a lot of work, it's important. Please value each other's opinions. Go back and see if you can reach a verdict. Sometimes they can't. And then there could be a mistrial. Does that mean you walk home? Well, if you're out on bond, it does for that day. But there could be a retrial. Sometimes prosecutors choose not to retry mistrials. Most of the time they do. So you could go back through that whole thing again. But let's say it's a not guilty. What happens then? You go home. Like right then. If it's a guilty, then you proceed on to sentencing. If it's a first-time offender on a felony, then the trial is bifurcated. Then you break into the sentencing part, and that's different witnesses. So that's where you can call sort of character witnesses, so to speak. And that's where the defendant may want to testify, to talk about his remorse, or his background, positive features that are going to endear him to getting a sentence within the lower range. If it is a prior offender, then the judge would impose sentence. Now, the jury recommends a sentence. The judge doesn't necessarily have to follow it. 9 times out of 10 they do, and you come back about 60 days later. Why that long? Because your lawyer has the right to file what's called a motion for a new trial, alleging error in the process. That's for the appeal. Like, let's say the judge made an errant ruling on the motion to suppress, or I tried to keep something out in what's called a motion in limine, which is a motion to keep out evidence that I would have filed. I believe the judge erred on that. You want to preserve all of those, because if you don't, they're going to be waived on appeal, and you want to have a shot at winning on appeal, even though there's a small percentage of doing that. So that is a broad overview of what a criminal trial entails, and it's sentencing. That's when the rubber hits the road, so to speak. It's where the judge grants allocution. It's the longest standing part of our law, grant of allocution, and that's like when in the Wild West, say, do you have anything to say before we hang you? That's basically allocution. Before I sentence you, do you have anything to say? And the judge gives that defendant opportunity to do that. And then off you go from there. I hope this has been helpful. Matt O'Connor from the O'Connor Law Firm.